Hello, welcome to Philosophy Roulette number 187, no 186, excuse me, where I read and review philosophy papers live on air. Forgot to get my mic set up. Anywho, let's get going. So let's see, does this need to be straightened out? It's okay. So let's see, I'm sorry. What's going on here? Let's see what's new. So you haven't done it in a few days and everything just breaks on you. It's typical life. Let's see. Yeah, this is fine. So what's new today? We've got Acta Biotheoretica, more Australasian Journal of Philosophy. Interesting. Just read some things from them. It was good. Let's see. Then we also read something from Episteme. That was fun last episode. I just released a few days ago, but I did it last week. See, we got British Journal for the History of Philosophy. I mean, why should I hate on AJP? Let's go check them out again, see if there's anything else to do. Complexity. No, I have nothing against Complexity or Ethics Quarterly, but, you could look at Business Ethics Quarterly. The Centaurus, I think is not in English. Complexity is a little too sciencey often. I can't just read science because I'm reading data. That doesn't work. Criminal Law and Philosophy, don't know that. Diametros, I don't know what that is. Educational Philosophy, Erasmus. Ooh, Philosophy and Economics. Again, quite often too technical, because if you're talking about technical economic things, it's hard to do. Ethical Theory and Moral Practice. Faith in Philosophy, let's take a look at that. Yeah, see, again, you can list common notions on theory of equivalence. Alright, so we got plenty of stuff to just take a quick look at. So, alright. Mencius Human, the Virtue of Humility. Alright, so this looks like a bunch of reviews. Historia. Yes, this is a review. Reviews. Was Bonaventure a four-dimensionalist? Interesting. So that's 11 pages. Let's see if that's even there. Review. Okay. Review. Okay, so we can look at that Bonaventure thing if this is available. I don't see it. Ooh. Oh, I clicked on it already. Why is that purple? That's interesting. 24 pages, that's why. But it's double spaced. Well, it's kind of double spaced. It's a little bit double spaced. So it's interesting. I've clicked on this before. Let's see why I didn't read this. I probably saw 24. Yeah, this is a long paper. Alright, maybe I'll come back to it. AJP. Let's see what's forthcoming at AJP. Oh yeah. I looked at a bunch of these things. Let's see. I read the Induction and the Glue of the World. I haven't done grounding in a bit, although there are plenty of grounding papers. Did I do Fallibility for Expressivists? I don't even remember. I might have. Let's take a quick look to see if these are available. This is available. Oh yeah, I flipped a coin and grounding lost. That's what happened. And Fallibility. And also that's there. Okay, so these are options. Let's take a look at what's forthcoming from Business Ethics Quarterly. Dangerous Work, Intention, and the Ethics of Hazard Pay. Alright, we've got an in memoriam. So it's only these two. Let's see if this is available. Let's just get some options for ourselves. Not available. Okay. So that's too bad. Nope. Alright. Criminal Law and Philosophy. Let's see what's coming up in Criminal Law and Philosophy. Review. Oh, 1 to 76. That means there's a bunch of these things. Review. Criminal Law at the Margins. I wonder what that means. Alright, let's take a look. Realm of Criminal Law. Let's just see what we got. See if these things are available. Nope. Of course, if you ever show up live, you can help me choose what to read if you have any preferences. You can go take someone else's word for it. PDF Springer. Let's see. We've got 12 pages here. Because I haven't read anything from criminal law and philosophy, so that might be something to do. Because just haven't done that journal before. Oh, look at that. Objectivism, misunderstanding method. Look at this. Alright, so it's right there. This is short enough. Well, it's 15 pages. This is interesting. I don't know if I've read anything from Diametros either. So then we got bioethics here. Ultrasound viewers' attribution of moral stats to fetal humans. Morality. So this was an ethics journal? Maybe. Yeah, it looks like it. Okay, so let's just see if folk objectivism versus realism is available. Yes, it is. Interesting. 16 pages, but single-spaced. No, thank you. That's long. I mean, well, not necessarily that long. But okay, so that's another thing. Might have to do that one from criminal law. I haven't done any legal philosophy in a while, so yeah, I've done educational philosophy, educational and theory, philosophy of economics. Have I done any economics? No. Oh, I hate that thing. I always keep forgetting to take it off or do something with it. More ethical theory. Let's see what's forthcoming. Well, I guess, a bunch of different journals started publishing again. They had like their summer editions come out because I was having trouble finding anything new for a while. Now we got a bunch. Okay, so that's good. Faith and philosophy. Let's see, is there anything forthcoming from these folks? Nothing. And foundations of science. The multiplicity of explanation of cognitive science. This probably could be very interesting. Special issue on a foundation of software science and computational structures. Oh, that stuff's always interesting. Philosophy of computation. People should, is one of those things like I mean to get around to. The philosophy of computers is going to be, of course, like super important going forward. And of course, have we a ton of philosophy in this? No, because it goes into philosophy of technology, ethics, all sorts of things, AI. So that's one of those, emerging philosophy topics that we're going to all have to get a lot better. We have to get like up on top of that really quick. Let's see. Approaching this one. Oh, I got to clean up my folders. Okay, so we're going to do this criminal law and philosophy because I have not done any criminal law and philosophy type stuff, so why not? So and if you are joining me live, the link is in the chat now, and if you ever come later, you can always type !paper and it will then show up. So it'll pop back up. And feel free to ask questions along the way. This is my first time reading it, so I don't know what's going to happen. We don't know if this is any good, but we can hope, and we will find out what this person has to say. So this is Approaching or Rethinking the Realm of Criminal Law by Nicola Lacey. And I apologize for how I say your name, too. While the realm of criminal law... Oh, is this a book? Oh, okay, so there's some sort of... it's an original paper, but it's on a book. Okay. I thought the realm of criminal law just meant like criminal law. And I was wrong in the first 4 words. Okay. While the realm of criminal law is informed in different ways by most of Duff's earlier books, its most obvious forebears are punishment, communication, and community, and answering for crime. In the former, Duff argued that punishment is best justified as a political community's attempt to communicate to offenders that the censure they deserve for their crimes, and through the communicative process to persuade them to repent those crimes, to try to reform themselves, and thus to reconcile themselves with those whom they wronged. Excuse me. And in the latter, taking off from a conception of human agency as the capacity to respond to reasons, Duff argued that criminal responsibility is one differentiated normative is... What's up, Sinful? Oh, Sinful, I also read philosophy papers and review them live on air. So this is like the other thing I do besides play Minesweeper on Twitch. So yeah, I read stuff and review it live and play Minesweeper. That's basically what I do here. Um, so yeah, this is completely different. Yeah, so yeah, it's kind of hard actually. But yeah, so yeah, if you want to, hey, what's up, Warden? Uh, yeah, so feel free to just follow along. You can download the link. I'll put the link back up if you guys want it. So you can grab the link there and you can download off that page. But yeah, feel free to ask questions along the way. So welcome. So Duff argued that criminal responsibility is one differentiated normative moment in a distinctive overall social practice of criminalization. He held that criminalization, taken as a whole, represents the institutionalization of one key idea that members of a shared political community answering to one another and calling one another to account for alleged wrongdoing. While in the current work, punishment is set in the background as a non-definitional aspect of criminal law, a move which renders Duff's substantial contributions to sentencing theory somewhat oblique to his current vision of the realm of criminal law. The previous themes of communication, censor, political community, and answerability remain key to Duff's vision, while the method of rational reconstruction or interpretation is broadly similar to the practice conception of criminal law theory articulated in Answering for Crime. Okay, so what we're doing here is like, this is just setting out sort of like the history very quickly. I mean, it's like a lot of big words here that I'm not used to saying because I'm not used to this area. But like, you've got all these books referenced up here, and then you've also got like just sort of some very complex sentences trying to just lay the groundwork for what's going on. So clearly this is just trying to move past the history to what the author wants to say. But it's an interesting, I actually very sympathetic to this strategy. Yeah. Well, I'm sympathetic. Me too, Sinful. That's like, wow, this went fast. But like, this is not, this paper's clearly not meant for the newbie, which I am in criminal law. Alright, so, but that doesn't mean we're not going to read it. Alright, so the realm of criminal law, however, of course, goes well beyond these two previous works in a number of significant ways. The purportedly modest aspiration is to develop a normative theory of criminalization, but a master principle, a thin formal principle that can illuminate proper basis for particular areas and modes of criminalization, specifying what could give us good reason in principle to criminalize a type of conduct. Thanks, Sinful, I appreciate the sentiment. A basis that, in contrast with the broadly unitary vision of punishment, communication, and community, is seen in pluralist terms. Alright, so we got some sort of big principle coming here. The master principle, that's always like a scary sort of thing. Master principle. The master principle adheres in the view that crime must be understood as constituting a distinctive kind of public wrong nested within a conception of civic life that binds citizens together. All right, so what we've got here is some sort of a community. So something that civic life that binds citizens together, and then there's some sort of wrong against that conception of like togetherness. So you're breaking the togetherness. You're breaking the togetherness in some sort of public way. So in some sense, that's interesting that it's inherently a public thing when you do something criminal. It's not a private thing. So I guess that makes sense that it has to be public to like the community. So when you break the law, you're doing something even if it's like in your private home, you're doing something in the public that the public cares about. So that's interesting. Like, what does it mean to be public here? Is it just that civic life, or is it in some sense like visible in some other way? Okay. On this conception, a public wrong apt for criminalization is one that represents a threat to civil order. All right. Oh, this is my 186th episode, Sinful. That's what it is. But within these parameters, many other considerations bear on whether the reasons to criminalize a practice, yeah, me too, Sinful, a practice concerned centrally with calling to account rather than with punishment are stronger than those against criminalization. So the master principle sets out a framework for criminalization in a very broad sense. So the master principle sets out a framework for criminalization in a very broad sense. Sorry, it's surprisingly hard to read chat and a paper at the same time. Thank you, Warden. Yeah, I'm a little surprised too. Where the conduct in question amounts to a public wrong, the master principle sets out a series of further questions that the legislator should ask before deciding to criminalize. Sorry, I don't have links. Yeah, no, you can, no, feel free to keep asking questions. It's cool. I don't mind. And, Warden, I don't know what you're going to post, but I don't let links because I get spammers come in here sometimes. And it's annoying. I mean, you can, like, just give me an outline and you can, like, break it up or something and Nightbot won't do it. Yeah. Okay. Where was I? How important it is to criminalize that wrong rather than to how to criminalize that wrong rather than to respond otherwise. To mark the wrong as a wrong by calling the offender to account for it through a collective and public response leading to a categorical judgment. The job of legislator is accordingly to construct a civic conception of public wrong out of pre-legal wrongs. Okay, so there's some sort of fundamental community thing that Okay, so there's some sort of notion of pre-legal. So the legal, in some sense, is calling it out, but there has to be some sort of underlying thing that you've harmed the community, and that's what the legal does. The legal sets out the wrong, but there has to be some sort of more fundamental wrong that the legal is just sort of corresponding to. Okay. This insight lays the groundwork for what Duff terms a modest form of thin legal moralism. For although crimes are distinctive forms of public wrong, criminal law is essentially concerned with moral wrongdoing. Okay, yeah, so it's like it's after the fact. So you've already done something wrong, and we already know that it's morally wrong. But then the criminal law is with the wrongdoing that's afterwards because it's already the pre-legal issue. Is already sort of, we already know it's wrong in our community, and then the criminal law is sort of coming after the fact. You've already done wrong. Okay. Only conduct that is censurably wrong should be criminalized. And far from seeing the extensive terrain of mala prohibita in instrumental regulatory terms, Duff claims that even so-called regulatory offenses constitute moral wrongs of a distinctive kind. Indeed, one of the striking features of the book is an extensive, if interstitial, critique of the notion of the view that a part of the terrain of criminal law should be seen in terms of morally neutral regulation. Indeed, in Duff's conception, criminal law is declaratory of pre-legal wrongs rather than, or perhaps in addition to, being in the business of constructing distinctively legal offenses. Yeah, so it's, again, after the fact, just sort of classifying things. Where was that word? Extensive critique. In terms of more neutral regulation. So you're basically regulating and identifying things. Yeah, declaratory. That's what I was looking for. It's declaratory. You're just declaring something that we already knew was wrong, but it's just making it sort of declaring it as such. In a sense, one could say that the only prohibitory norm in Duff's schema, reminiscent of Tony Honoré's 1977 famous argument in his essay Real Laws, is the instruction, do not commit criminal offenses. Moreover, it is not clear that he regards this as a legal norm or rather a moral political norm. Criminalization gives the citizen a reason to obey. A regulatory offense may be wrongful only because it is prohibited by the law, but the law that prohibits it is not the criminal law. Sinful ass, isn't this basically put just knowingly doing bad things in the society? Well, see, that's the question here. This is a philosophy paper, so what's going to happen is, I think the author is setting this out as you're saying, but then they're going to say something where they either disagree or agree for some reason afterwards. So this is all still set up in terms of this paper. This is only, the third page or something? Yeah, page 3. So we've got some real fast background here. This is starting the setup here of what they're doing, because I got master principle, and then they're starting to define how this master principle works. It's declaratory, and then what's going to happen is they're going to put the smackdown, or the support is coming later. So in terms of how a philosophy paper works, it's background, setup, and then then argument quite often. That's what it looks like is happening here. Background, setup, and argument in terms of how this is going to work. So this is the setup. We're calling it a declaratory master principle, and then this is like the conclusion of like this setup, and then the distinctive feature. Yeah, see, and then we're going to continue here, and the distinctive feature is going to get criticized or not criticized. Okay. Other distinctive features of this volume include a far more explicit embrace of republicanism as the background political theory, informing the notion of criminal law as defining and proscribing public wrongdoing. See, now we're going political, so the author here is expanding on what the implications, because it also not just criminal law, but the political theory that justifies this sort of that this also is justifying a political theory, or other way around. So it's now it's not just in criminal law, it's political also. So now they're making it sound more important, because it is more important. Okay. Prescribing wrongdoing. Generating a conception of civil order as political rather than exclusively moral. So yeah, political is rather than so as I was saying, this is how this part of what I like to do here is actually explain how philosophy gets written and generated. So what you've got is you've got background, you've got some sort of then you've got the setup of the argument, and now what the author doing in this paragraph is expanding beyond the limited sense that they had already set up. So now we've got not just ethical, but we've got political. So we're expanding the significance here. Okay. An extended and very illuminating analogy between the norms of criminal law as a form of moralized public law and the professional ethics of institutions such as legal and medical professions, and a far more extensive development of Duff's response to the evident difficulty for any liberal communitarian theory that the conceptions of the value and wrongdoing that inform criminal law may not be universally shared, even among members. I shall have more to say below about Duff's treatment of dissent and so-called recusants. And finally, though the modification is intended to by no fanfare, Duff appears in the book to have dropped his previous commitment to the proposition that penal censure by definition requires hard treatment. All right, yeah, see, not just political, but we've got also institutional stuff, which includes medical professions. So now we've gone even past law and politics, but into how we treat people as medical things, health-wise. Okay. In this review article, I will not attempt to assess the full and impressive range of Duff's thinking in the realm of criminal law. Yeah, see, it said a research article, but this is really a review article. So this is not what I was expecting, but that's cool. And that's also the reason they kind of went so fast, because they're reviewing something and they're expecting people who knew stuff already to be reading this. That's because they're reviewing something, not just trying to set out new philosophy. But yeah, that's one of the reasons this is kind of going quick. yeah, the YouTube is like, it's gone, 180. The question is, thanks for stopping by, Sinful, I appreciate it. Is the master principle based in morality, or is it based in something different? Asked Warden Uma. I don't know. I haven't read the background stuff here. I think what they were saying is you're just sort of assuming, maybe there is an argument, but it looks like what they were saying earlier is that we're assuming that there's some sort of pre-legal understanding. Now, is that based in morality, or is that based in maybe something else? I don't know. It might be some sort of underlying moral theory, yes, but it wasn't specified. So it's likely, but that doesn't mean it's the only option here. There could be some sort of underlying fundamental political theory that could underpin this. I don't think so, but like maybe there's some sort of understanding of human interrelationships, and that's why like some sort of fundamental communitarian theory, like we have to live in communities, and therefore if you're harming the community, therefore then you get censured if you do something that harms the community. And that might not be considered a moral principle. That might be considered a political principle. I don't know. Okay, continuing. I will not attempt to assess the full and impressive range of Duff's thinking in the realm of criminal law, but will rather concentrate on 3 areas in which I find his views less than fully convincing. The first is methodological and has to do with 2 ostensibly different, but in my view different in my view, in fact-related issues. The way in which Duff's interpretive theory or effort of rational reconstruction conceives its subject matter, and Duff's attitude to interpretive approaches such as Farmer's, Alan Norrie's, or my own, which insist on the relevance of the historical development and the institutional practices and doctrines of criminal law. Thanks, Warden. I appreciate you guys stopping by. The second, which in some ways flows from this methodological point, has to do with whether even a modest or thin version of legal moralism can truly capture the distinctiveness of criminal law as a system of social norms in contemporary systems of England and Wales, Scotland, the United States, or indeed other modern states. And the third, again, flowing from what I see as the inappropriateness and even the risks of legal moralism as a way of understanding criminal law. Yeah, so if you're still here, Warren, I think you're right. This is a legal moralist theory. Focuses on the way in which Duff's account is embedded within a public philosophy of liberal communitarianism in which citizenship functions as the paradigm of full membership in the criminal law community. Here I ask whether Duff's elaborated analysis of the state's proper response to dissent falls some way short of the aspiration of inclusiveness explicitly envisaged in his earlier work and an underlying theme in this latest book. Okie dokie. So as I was saying to Sinful and Warden, all that stuff was set up, and then here's the kicker. This is what the whole point was. It's that once you have the setup, and then here's what is going to be said, here's the problems. It's not to say that, of course, the book here of Duff's book is actually that bad, or is even really that problematic, but this is discussing some of the counterpoints that are going to arise if you have if you take on Duff's view. Oh man, I have a Duff beer shirt. I feel like I should have been wearing that. I apologize to Duff for Duff beer, but still, thinking about my Duff beer shirt. 1. Mapping the realm of criminal law. Duff's book opens with a relatively parsimonious statement of his method of rational reconstruction, and with a decisive rejection of the need to engage with the historical development of criminal legal ideas and institutions in a particular system. He also rejects the claim, it is not entirely clear to whom this is being attributed, that philosophical theorizing about institutions such as criminal law starts from nowhere. Yeah, that's interesting. Why would anything start from nowhere? Duff then gives a succinct account of his approach. Oh yeah, and of course, don't feel bad about interrupting me, folks, if you're here. Yeah. So Duff then gives a succinct account of his approach. The beginnings of our theorizing are local or parochial. But that is not to say that we cannot hope to transcend those local beginnings to engage with a wider we. Nor is it to say that we must take for granted as unchangeable given the particular institutions and practices with which we begin. First, we can hope to engage in a process of rational reconstruction of those institutions and practices, to excavate or reconstruct the goals and values by which they purport to be structured, to reconstruct, I keep rereading this rewrite there. To construct on that basis a theoretical account of what our criminal law claims to aspire to be, and in light of that account, to critically evaluate our existing practices by way of an imminent critique. Okay. Duff goes on to suggest that this imminent critique can then be extended by reference to the values similarly explicit in the broader understandings of polity and of civic life in which any system of criminal law is embedded. And he argues that it can be further extended beyond the boundaries of a single system so as to engage with other localized practices and values with which we find that conversation is possible, and from which we may derive inspiration about how further to improve our own system. The core material for this rational reconstruction through which Duff aspires to come to an understanding of criminal law as a distinctive kind of institution as identified as what I take to be central aspects of our Anglo-American systems of criminal law, and that I believe is also recognizable in other legal systems, notably those of other contemporary Western democracies. There is a common sense appeal in Duff's argument, but the more one thinks about it, the more apparent it becomes that this way of delineating the terrain over which the object to be theorized operates leaves an extraordinary amount of latitude to the theorist, inviting the thought that prescriptive and or aspirational rather than merely rational reconstruction might be a more accurate way of describing how the method works. This is a massive and interesting sentence. Like, wow. I mean, just like from this butt. I was like, okay. So this is like, you see, this is this setup here. There is a common sense appeal in Duff's argument. All right, so this is a setup right here. Like, this is just a setup. Like, this is a big setup, and then here comes the smackdown next. This is common sense, but the more one thinks about it, boom, this whole thing is gonna fail. It leaves an extraordinary amount of latitude. So it's putting all the weight onto the theorist. So it means that it's completely it's in the theorist's head because it's prescriptive or aspirational. The theorist just like basically putting their ideas out into the world, then merely rational, which would be in some sense, in this case, sticking to the concepts itself, the way things are. So this is the start of the criticism, like the hardcore criticism actually, because this is all describing things, and then all of a sudden now it's like nope. This is aspirational, not rational. Okay. In other words, the normative vision that is distilled by the theorist from the vast array of rules, institutional arrangements, and practices involves a process of selection that is itself inevitably shaped by norms and values that are also the ostensible outcome of the process of theory building. Indeed, this becomes explicit in Duff's further defense of his method and in his admission that his picture does not fit all of our existing practices of criminal justice. Interesting. So, Duff even knows that does not fit our existing practices. See, that's interesting. If you're going to start talking in philosophy, then if you're saying this is not what we actually do, then you're giving some sort of prescriptive, but it's not and then you have to say why. Okay. And I must say, the writing here is kind of interesting. These are very sophisticated sentences. I mean, we've got the ostensible outcome of the process of theory building. This is a little, you've got some, the timing on these words are interesting. So, whoever this author is, this is some interesting writing. I mean, I kind of like it, but it's just kind of, it's complex. I continue to think, see, and then we've got an I right here. All of a sudden, we got like a first person. So this is interesting stuff going on, at least in terms of the writing style, because there's no I's. This is the first time I think there might be an I in this paper. So it's just interesting for anyone looking from a writing perspective how you could look at this author and see that something else is going on also when they're writing here. I continue to think that the sense that practices are sometimes answering to theory rather than the other way around raises important questions about the particular genre of criminal law theory of which Duff is such a gifted exponent. And my view here is reinforced by the rather axiomatic quality of some of the book's more abstract discussion, notwithstanding Duff's assiduousness in providing concrete examples of criminal law as answering within a moral community. Duff aspires to draw out from criminal law a core concept that both informs the social practice of criminalization and generates a normative vision on the basis of which that social practice may be criticized and reformed. Duff argues that any normative theory of criminalization must depend on an account of what criminal law is for, which must in turn depend on an account of what criminal law is, what are its distinguishing features. But if, as is implied by the very method, the object of exercise is to produce a theory with robust normative credentials, then the theory cannot, by definition, answer to every feature of the practice. Some part of the institutional practice must be jettisoned as unwise, unjustified, or incoherent. And in selection of both features to be emphasized and those to be marginalized or criticized, the normative frame of the theory itself, the vision of what counts as the best interpretation, is implicated. Hence, this method is characterized by a certain circularity and lack of clarity about the precise balance between explanation, rationalization, and prescription. Okay, so what's going on here is it says, look, no matter what you're going to do, you're going to be, since this is sort of defining what it is to be a good community and then what you need to fix in the community, it can't actually adhere directly to our practices because it's trying to change our practices. But then if it's trying to change our practices, it has to say in what way, and then you get into a circularity, because it's like, well, if the practice is this way, but it shouldn't be a certain way, and it should be better in a different way, but then it reflects back on itself. How should things be? So, I mean, a lot of philosophy is like that. A lot of human life is like that. Anything to do with society is reflective of society. So it's like, why is something good? You need something else to inform your discussion, like how society is, where you have to appeal to a theory. But so if you both inform the social practice of criminalization and generate normative vision on the basis of that social practice, then you've got, well, two things, and they're dependent on each other. So this is just pointing out, in some sense, that what's going on here is not particularly clear, because if you're giving a prescription, then based on what, especially if you're basing your prescription on the way things are. This is an interest. Yeah, the way this is constructed is actually kind of interesting, this argument. Okay, continuing. For most criminal law theorists of a moral stripe, the litmus test for how this methodological issue affects their approach is the significant terrain of strict liability offenses. These are all too often marginalized as peripheral or even ignored in moralist accounts. To his credit, Duff recognizes the existence of these offenses in our criminal law, and instead of marginalizing them, brings them within the legal and moralist fold by insisting that their commission should be regarded as genuine morally wrong by reference to the overall master principle of criminalization. Specifically, these offenses have been created because of their impact on civil order, which may be on occasion be such as to justify their standing as public wrongs. This is, in my view, both a more honest and more imaginative take on strict liability offenses than the marginalize or ignore strategy. But when I try to enter into Duff's imaginative project and engage in my own process of rational reconstruction, I have to report that I do not find it convincing to interpret the regulatory crime in a moralized way. Yeah, so I guess this is the basis of what's going on here. There's a rational reconstruction, and that's kind of what you have to appeal to. You have to sort of conceive of things in a rational way, and then you will, if you do it in the way Duff imagines, then you'll understand Duff's point of view. And that supposedly is giving an independent basis for why and how we are to change the criminal law here. But the author is not buying it. Does not find this sort of understanding of thinking of things in Duff's way convincing. Okay. More convincing to my mind is a sort of view of criminal law emerging from Norrie, Farmer's, or Chow's work, in which the distinctiveness of criminal law as a set of public coordinating norms in countries like England and Wales today has been shaped over time by the interplay of ideas, interests, and institutions. Hence, the contours, modus operandi, and role of criminal law today is strongly associated with the developing structure and imperatives of governance in, as Chow puts it, the modern administrative state. This is a view to which I will return in my discussion of Duff's account of regulatory criminalization in the next section. It is, of course, an interpretation that comes into view far more readily if we think of criminal law diachronically, as nested within broader institutional structures that have developed decisively over the last 200 years. Seen in this way, the rationale for criminal law as a form of public law is far more distinctive than that in legal moralist accounts, in which one way or another regulatory criminal law is always going to be an outlier or in need of special explanation. Okay, so if you're talking about it according to Duff, according to this author, is in a legal moralist account, then you're trying to figure out, all right, well, it's how you're going to deal with the criminal stuff is always an outlier because the fundamental is the moral stuff. And then the criminalization, of course, is sort of like after the fact. What do you do about it? But then if you're treating the criminal law as part of the interplay of society, as a sort of a normative thing, the developing structure and imperatives of governance, so it's a coordination problem, coordinating norms, then the criminal stuff is actually part and parcel of how governments operate. I mean, I'd kind of worry at that point that, like, being treating things as criminal is basically baked into the state, and maybe that's a good thing. But then the moralizing is saying, well, we want to get rid of the criminal stuff, and maybe you feel like that's better, that there is nothing particularly criminal about people. Again, that would be rather idealistic, wouldn't it? But then again, on the other hand, baking criminality into the state might be an idealism of the state too, how you idealize the state. So I guess maybe this would be a fundamental disagreement on how to view the state, and that is kind of what is going on with the disagreement between the author and Duff at this point. Yeah, that's interesting though. So what's the fundamental norms going on here, and what is Okay, continuing. This judgment may, I think, be reinforced by reference to the fruitful professional ethics analogy that Duff develops and deploys in this book. Codes of professional ethics, Duff argues, carve out a restricted realm of wrongdoing relevant specifically to the res publica of a profession and are shaped on the basis of context relative conceptions of what is public. What is really productive about the analogy is precisely the way in which codes of ethics in professions, such as medicine and law, embody a distinctive set of norms that underpin the pursuit of potentially valuable and yet potentially harmful social practices, and in doing so express the priorities and aspirations of that practice as understood by its governing body or bodies. But we can surely view such codes in this way without thinking in terms of thin professional moralism. Notwithstanding a substantial overlap with the moral norms such as honesty and integrity, the particular contours of professional regulation are driven by the particular goals, needs, and constraints of that professional practice, and are better understood in these discrete terms than as a subset of broader moral norms. The analogy with codes of professional ethics, in other words, points us toward the political and the regulatory rather than the moral foundations of criminal law. Indeed, Duff in some ways accepts as much in his conclusion that restricted understanding of public... Let me reread this. Indeed, Duff in some ways accepts as much in his conclusion that the restricted understanding of the public implicit in liberal republicanism militates away from the sort of expansive legal moralism adopted by Moore, and in some important but undeveloped concessions to Chow and Thornburn's views. In short, I agree with Duff that in professional ethics, so in criminal law, but I draw precisely the opposite conclusion from the analogy. Okay, yeah, so again, what are you appealing to? You're appealing to the profession here, but the author here doesn't buy that. But that's what the author is saying Duff does. So Nicola is saying that appealing to the profession is not what you should be doing. Okay, probably the clearest example of the theory in the driving seat tendency in Duff's current book is, however, his treatment of plea bargaining. Again, unlike some ideal theorists inclined to legal moralism, Duff is clear-sighted about not merely the existence but also the extent of plea bargaining. Yet, while acknowledging that a realist might regard his approach as philosophical fantasy, he insists that this reality should not be allowed to displace the centrality of contested adversarial trial understood as a calling to account within his overall rational reconstruction of criminal law. But can this view really be sustained? Given that the vast majority of cases, both in the United States and in England and Scottish systems, are resolved through some form of plea bargain, the question must arise as to whether the trial as calling to account retains precisely the same place within our criminal law, and of whether any significant institutional change in practice over time would demand adjustment of the interpretive theory of criminal law. This is where Pache, Duff's distancing of any need to engage with history from his own methodological viewpoint, the bracketing of change over time diverts attention from the way in which criminal law is shaped by its dynamic interactions with both state structures and social cultures, a process that is thrown into sharp relief by a historical as by a properly comparative perspective. The growth and institutionalization of plea bargaining has, in short, changed criminal law in ways that call to be accommodated in any reconstruction of its realm. Okay, so we've got a counterexample here with, in terms of plea bargain, because instead of actually using the trial as this sort of public moral arbiter, it's the plea bargain, which is not a like trial by jury. It's not public. It's basically you're getting some lawyers together and trying to hash things out and make a deal. So it's not this public thing in terms of like resetting the wrongdoing in a public way, but instead you're now dealing things with plea bargain, and so you no longer have the practice has moved away from the theory, is what the author is saying here. So Duff's understanding treatment of plea bargaining, the author is saying, is wrong because the practice doesn't accord with what Duff says in Duff's sort of idealistic understanding of things. Note, too, that my argument of any rational, as opposed to prescriptive or aspirational reconstruction, would have to account for the role of plea bargaining within the criminal law is absolutely consistent with the possibility of a robust critique of plea bargaining in both its substance and its execution. Yes, if it's rational, it just has to follow from the understanding, but it's not following. It's from what it is, because it is not what Duff says it is. But if it's prescriptive, then Duff is saying, well, this is what it should be. But in the author sort of adding some defense here, saying, look, that's not to say you can't criticize plea bargaining, but it wouldn't be what what Duff says it is. But such a critique must grapple with a large range of questions in political philosophy, notably in relation to the appropriate priorities of modern democratic states in coordinating social behavior and pursuing the public good. Among these, of course, would be, you have a question: do you think there should be a set amount that a crime is worth? Do you think it would cause an uproar or any confusion, or should it be charged case by case? In terms of this politics stuff, there's no set amount. I mean, the old concept of like the Hammurabi, whatever it was, the eye for an eye from thousands of years ago, was set up because rich people there used to be a set amount things were worth, and rich people would just pay it off. They'd just pay off the debt. And so when you have a set amount, like here in the United States, like say you get a speeding ticket, and it's it can range from $50, or like you run through a red light, it's like $50, or like a few $100. But if you're rich, that doesn't count in any way because you don't care, because that's an insignificant amount of money. If you are poor, then that might ruin your whole week, month, year, for all you know, by setting you back. So the idea that there's a set amount, the set amount is not relative to the people in society. So I actually don't think there should be a set amount. I kind of like the Scandinavian idea where if you're rich, the ticket scales with how much money you have. So like for rich people speeding, it would be like millions of dollars. Poor people speeding should be like $50. But the idea that there's any sort of set amount that negatively impacts, that over impacts poor people, because for them that'll be a lot of money. For rich people, they just get away with it. That's why you see rich people like getting parking tickets all the time, because that amount of money is insignificant to them, and that just gives them a pass to break the law, and I don't like that. I mean, why should they get to park wherever they want? So, yeah, much more on the case-by-case side of things for me. I mean, I know that puts a lot of overhead on the legal system. But yeah, I mean, I don't like, because you're just over penalizing poor people otherwise, and I hate that. But yeah, this is the problem with a lot of people like flat taxes and like flat fines, and this is the problem. It usually ends up benefiting the rich people. There's a reason why it's always it's overly, like, it sounds great, but in practice it doesn't work. And so you get, if you look at who is pushing those things, it's a lot of times they're paid by very, very wealthy people. It's just, that's a sociological point. Okay, where was I? Yeah, this is what this comes with. Critique must grapple with a large range of questions in political philosophy, notably in relation to appropriate priorities of this is exactly the issue that's going. What are the appropriate priorities in modern democratic states in coordinating social behavior and pursuing the public good? This is exactly what the question is about. Among these, of course, would be questions not only the proper extent of criminal law, but also the proper scope of fair taxation. Exactly. Fair taxation. In this regard, it is simply not clear to me why Duff questions what space historical or sociological informed criminal law scholarship leaves for normative theorizing. Indeed, he himself cites work by both Norrie and Chow that establishes the contrary, with Chow's case for what he calls pragmatism rather than formalism. Thank you, Warden, for hosting me. Formalism in criminal procedure, an excellent example of how such scholarship can both inform and sit comfortably. This is my first hosted. I don't think I've ever been hosted before, so thank you. Just realized, yeah, no one's ever hosted me. Yay, I've been hosted. Excellent example of how such scholarship can both inform and sit comfortably alongside what I have called normative reconstruction. Moving up in the Twitch world, I've now been hosted. Wow. It's great. What is at issue here is the relationship between a theory and the phenomena that it seeks to present, rationalize, or justify. A hugely important nexus between prescriptive moral and political philosophy and the phenomena that provides their focus turns on the feasibility of our normative arguments. See, feasibility, we're going like, is it even possible? This is sort of realistic sort of theories, not aspirational ones. That typically depends on things like human psychology, the capabilities and responsiveness to reasons or incentives of human beings, the institutional capacities of political systems, and the alignment of interests in particular social contexts. In the philosophical literature on criminal justice, many of the most powerful voices, Duff's among them, make a careful distinction between ideal and non-ideal theory and temper their conceptions of the latter to what they take to be real-world constraints and conditions. Yet, in this book, the method of rational reconstruction blurs the line between ideal and non-ideal theory, producing a hybrid as ideal as possible theory whose appeal is fundamentally one to shared institutions about the centrality of certain values. It may be, of course, that Duff would want to argue, as at some points he does, that arrangements such as strict liability and plea bargaining are unjustifiable practices that should be discontinued on the basis they are incompatible with the normative vision of the criminal process as a species of moral communication between citizens. But if so, it becomes clear that the boot is very much on the prescriptive or aspirational foot. A vision that excludes so substantial a part of the terrain of contemporary criminal law cannot fairly claim to constitute a rational reconstruction. In my view, Duff's conception of criminal law as a distinctive social institution embodying a distinctive form of civic life, with its tantalizing yet undeveloped Wittgensteinian resonance, could have been enriched by a much closer engagement with, say, Farmer's account of the changing priorities and understandings of criminalization during the course of English-Scottish history, or with Chow's or Thornburn's account of the role of the modern criminal in sustaining cooperation with the public institutions or in underpinning governance with a particular constitutional order. Note, too, that the proposition that ideas and ideals have institutional and other conditions of existence is perfectly consistent with the enterprise of normative reconstruction. It simply invites a constructive and open dialogue between such a theory and what we know about the world. This is entirely different from the claim that everything reduces to historical contingencies, which undermines the very basis of theorizing complex social practices, such as criminal law. Okay, so this is the upshot, is that if you're going to have this sort of the sort of reconstruction that Duff wants, it doesn't fit with practice, and then you can't call it a rational reconstruction. It's just merely aspirational. This is ideal as possible theory, but it doesn't make sense because the society has moved well beyond the understanding that Duff has. So, that's interesting. I mean, that's a good criticism as I don't know if it's a good criticism, but this is a well-organized argument, and it shows that if you buy this author's claims that what it means to be a rational reconstruction, and then Duff hasn't done that by Duff's own lights, then there is a problem for how Duff has argued for whatever it was. 2. Thin enough legal moralism, the puzzle of regulation. In the realm of criminal law, Duff openly admits the difficulty of reconciling extensive plea bargaining with his legal moralist conception of criminalization, thin and formal though it may be. It is nonetheless true that his discussion of the matter is relatively brief, according a more central place to a range of procedural arrangements that are commonplaces of what we might call everyday criminal law, the empirical dominance of summary justice, or practices of diversion from the criminal process, for example, would have made it much harder to present the legal moralist picture with its paradigm of prosecution. Oh, dude. Okay, I complimented you earlier on the writing. This is a problem. You've got 3 long dashes, and it makes it very hard to figure out what's going on in this sentence. But yeah, with its paradigm of prosecution and contested trial as a rational reconstruction as distinct from an ideal. Okay, so we got 4. So it's just the problem, we've got 2 emphasis dashes within one sentence. And when you're reading this in real time, it's a pain because I don't know what just happened there. Let me reread this for a second. Okay. The strongly moralized tincture of his overall vision sits, after all, somewhat uncomfortably with the reality of these pervasive features of the contemporary criminal process. Nonetheless, at various points through the book, Duff makes a substantial and original effort to tackle head-on the implications of so-called regulatory criminal law for a legal moralist approach. In this section, I will step around the welter of distinctions through which Duff constructs his particular notions of legal moralism, negative versus positive, exclusive versus non-exclusive, and his master principle, which he sees as thin and formal yet foundational, exhaustive, exclusive, positive, pro tanto, and primarily responsive rather than preventative. Is it just me, or is there a hanging, okay, no. I'm just losing my mind at this point. Is this a hanging parenthesis here? Yeah. Okay. Instead, I shall try to piece together Duff's various interventions on this point during the course of the book, and suggest that, like the professional ethics analogy, they should lead us away from legal moralism and not toward it. And feel free to ask questions. Like I said earlier, I'm doing my best here. I don't know what's going on. On the one hand, not everyone wrong, not even every public wrong, will call for criminalization. Duff, of course, envisages the existence of other forms of regulation, and indeed argues in Chapter 7 that many current forms of criminalization, notably both certain forms of regulatory strict liability offense and the expanding terrain of preemptive offenses, have overstepped the proper bounds marked out by the master principle. He expresses a preference for the institutionalization of a clear distinction between regulatory infractions and genuinely censure-worthy acts. The German system presents a good example of such a distinction that are, in his view, the core terrain of criminal law. Yet he leaves open the door to regarding some regulatory infractions, tax evasion, certain driving offenses, and breaches of health and safety norms, for example, as appropriately criminalized. This regulatory criminalization should, in his view, take place within a distinctive framework governing decisions to prosecute, which should be taken here not as the basis of strict legality, but of what he calls a discretionary principle of opportunity. That is, the enforcement strategy should prioritize giving offenders maximum opportunity to comply, with criminal enforcement being invoked only as a last resort. Hence, while regulatory offenses are indeed brought within legal moralist frame, mala prohibita, are genuine wrongs that consist simply in the breach of a legal regulation that citizens ought to obey. Duff continues to assert a distinction between real and quasi-crime. Yeah, this goes... I don't know, I really don't know criminal theory, or it goes back to anything. As far as I know, this only goes back to Aristotle, where we've got it's an ancient distinction between civil offenses and criminal offenses, and so some things are civil and some things are criminal. And what's terrible is the last time I saw mala prohibita was what's that with Reese Witherspoon, was it? Legally Blonde was the last time I saw that. I heard this term. I love that movie. It's great. And also the other legal one was My Cousin Vinny. Kind of going back to all those. I love those movies. At other points, Duff's statements of what counts as a criminal conduct, civil wrongdoing, civic wrongdoing as distinct from harm causing, is such that it seems inhospitable to a wide range of regulatory offenses than those canvassed earlier in the book, wrongs that require categorical recognition and condemnation rather than nuanced negotiation and compromise. Moreover, his position on strict liability, which in fact attracts only a handful of references, is somewhat unclear. His initial statement explicitly states that we should object in the strongest terms to liability without fault. Perhaps he has in mind here a particular case of absolute liability where even a due diligence defense does not apply. Later on, however, he argues that adjusted burdens of proof and modified fault requirements and penalties marking out a particular train of regulatory violations within quasi-criminal law may be justifiable within the master principle on the basis of modified enforcement policy set out above. His final position is that such regulatory criminalization may be justified under the procedural conditions just stated so long as they respond to some significant aspect of the polity's common good, the need to guard against the dangers created by driving or industrial manufacturing, or to raise revenue for the public purse, or to protect the immature against sexual exploitation. They will appeal to our civic responsibility to contribute appropriately to our common good, and they will show how the regulations are well designed to serve that aspect of the common good. Okay, again, just discussing the setup of this argument. Since section 2 is basically a reset of the sort of whole argumentative structure here. This author is very sort of methodological, you could say. They set up, they do a little history, they establish the basis of what they're talking about in terms of the author here, the setup, and then we've got a yet. It's like very clear. And then this is the what the author is going to criticize. So it's a very clearly structured paper, this one here. And I mean, you can just see it. This could even have started off a separate paper right here, because they restart the whole sort of argument. So it's just an interesting way that this is that this review article is written. It could have been it could have been made just sort of modularly, where the different pieces aren't even related to each other. So it's just interesting in terms of how you're going to write your paper. Some people have one big argument that goes all the way through. Some people take things out piece by piece. This one is like it's like every piece could have been rearranged. So it's just sort of an interesting way it was written. Is very sort of everything is self-contained here, which is interesting too in itself. Yet the moralist quality of Duff's theory in effect constitutes mala in se in the paradigm of criminalization, with all the effort going into the question of how to bring regulatory crime within the moralist frame, rather than investigating in any detail the regulatory quality of the entire train of criminal law. To return to the methodological questions posed in the previous section, how would Duff go about persuading us of the superiority of his account as a rational reconstruction over, say, Chow's, with its powerfully argued view that moralism puts the boot on the wrong foot and turns its back on a profound transformation of criminal law in modern administrative states over the last 3 centuries? The question, for example, of whether a prosecution policy should be crafted a la Braithwaite's influentially regarded pyramid on the basis of opportunity far more generally, or of whether institutions such as plea bargaining may have developed in part precisely as strategies geared to maximize the effectiveness of criminal law as a regulatory system, quite generally are not directly addressed, with the discussion of Chapter 1.7 somewhat inconclusive as to whether Duff regards the prosecutorial discretion that undoubtedly exists across the English system as consistent with the democratic credentials of criminal law. Moreover, as Duff himself acknowledges in his final reflections in the supposed mala in se, mala prohibita distinction, there is no clear line between these aspects of criminal law, since many offenses usually seen as mala in se have regulatory dimensions that cannot be neatly bracketed. Yet the full implications of this point are not explored. Indeed, they cannot be explored within the framework of even a thin legal moralism. Okay, so this is the second argument here. It's clearly shorter than the first one, but like you've got this distinction between what sort of crimes need to be prosecuted in terms of criminality, and then it breaks down because it's just it's not clear what to do under this. If you're going to have this distinction, you need to be clear about what gets prosecuted, but apparently the author is saying you can't do that here. So okay, that's interesting. And let's go on to the third one. Number 3, dealing with dissent, the citizenship paradigm. Granted that any moral deliberation assumes a set of values that derive from some normative community or other, a key difficulty for any approach aspiring to rational criminalization by appealing to the substance of criminal law appears to be that of identifying a sufficiently rich and shared set of values across the relevant territory, and of justifying their imposition on those who either are not members of the relevant community, or, as Duff acknowledges they might, utterly reject its values irrespective of their membership status. I just want to point out this was one sentence. Citizenship operates as the paradigm of membership in the relevant moral community, with a central reference point in the polity's shared values. Duff, but at least this author understands what is going on here. A very long sentence, at least followed up by a very short sentence. You're allowed long sentences in philosophy, so this isn't really a problem. It's just a problem when you're reading it like I am, which is very unusual, I grant. Duff concedes that a Rawlsian overlapping consensus on these values may not exist. His readers may in any case question the place of such an idea within a master principle that purports to be procedural or formal rather than substantive. Interesting. Okay, so if you're just going to define it, but then you can't appeal to like a big sort of the community. Okay. Alright, so let's see what the author says. Within this vision of liberal republic organized around solidarity, because you need the community to back up this sort of theory here. As the moral community, it needs to be substantive. But if you're going to have the master principle just be institutional and thin, where is the moral community existing in that case? Alright, so that's the question. Within this vision of a liberal republic organized around solidarity and geared to the common good and not to non-dominion, citizens are the primary addressees of criminal law, but the doctrine of jurisdiction implies that non-members may also be addressed by the criminal law without disrespect. Indeed, Duff advocates an inclusionary concept of citizenship within which, for example, a long-term resident is substantially a citizen, while temporary residents are guests subject to the norms and duties of hospitality. But the application of criminal law to non-citizens turns not just on a legally specific claim of jurisdiction, but on the moral basis of the law. On Duff's view, criminal law declares rather than creates wrongs. Where such wrongs are committed within its polity, they are always the law's business. Even if we allow the dubious assumption that the dominant values can readily be identified with a pluralistic society, it is not clear, however, that Duff's readers will or should be entirely comfortable with the extent to which his approach, notwithstanding its claims to express a liberal vision, aspires to the internalization of the dominant community's values, nor that she should be comforted by the suggestion that the offender be invited to express his or her dissent. Readers may also struggle with Duff's suggestion that citizens have a civic duty to play an active part in the trial. This is an example that stretches the boundaries of rational reconstruction given long-standing common law norms such as the privilege against self-incrimination. I keep thinking there's an L there. Self-incrimination. That's a pretty normal word, actually. Conversely, the recent erosion of these norms in the English and Welsh system has been argued to raise normative concerns about the implications for defendants' autonomy. The historical association of the word recusant with religious dissent is perhaps apt given the moralist quality of Duff's approach, but will add to the discomfort of those like myself who prefer to think of criminal law in political and regulatory terms. Duff's is a painstaking and thoughtful attempt to balance what he sees as the good of civic order and the liberal impulse to toleration and inclusiveness, but it is not clear what this space his vision leaves for the important phenomena of resistance and debate in a pluralistic society, phenomena that have, even within the short compass of the last 30 years, brought about fundamental changes in the realm of criminal law in areas such as sexuality or drugs, areas that should sound cautionary notes for the assumption of legal moralism. And particularly in a world in which the dangers of demonizing groups constructed as outsiders, whether because of their migration, ethnic, religious, or political standing, are all too apparent, we should worry about Duff's reluctance to conclude that a polity cannot or should not make full membership as a citizen conditional on the absence of persistent criminal behavior, that it cannot or should not exclude, at least from full citizenship, those who persist in violating its laws. Yeah, this is the problem, of course, because, of course, if you're a refugee, you're going to break some, like, international law, but then who gets to be a community if you're inherently breaking a law? I mean, we have this problem here in the U.S. They're breaking our law. They're coming onto our shores illegally. But, of course, they're running for their lives. I mean, people here always say, well, they're going to leave the U.S. I mean, you're running for your life and your family's life here, and then you're going someplace else. But that's exactly what the immigrants from, say, South America are doing at our southern border. They're running for their lives. We should be compassionate. But this is saying here that, look, if just you're breaking the laws, well, what laws, and why are those the important laws? And since the community changes around sexuality and drugs, it's like, well, then you're defining laws basically on what, and why should that be the basis of being a citizen of that country or that nation or whatever. Okay. Granted, Duff accepts that not all citizens will see themselves as sharing the goods that the polity defines as their common good, or see the polity civil order as their order. Yeah, so who's defining what the polity civil order is? But he does not see this as a necessary aspiration for a polity. And while the recusant's rejection of the associative bonds of citizenship, here the recusant is defined in very stark terms as someone who does not identity the polity's common good as any part of their good, does not itself undermine her citizenship. With the relevant associative obligations, Duff is prepared to canvass offering such recusants the option of becoming long-term guests or resident aliens rather than citizens, though at the end of the relevant chapter he reverts to thinking them as critical citizens. He also emphasized that both the pre-legal moral reasons to obey the law and the reach of associative obligations to all within the jurisdiction imply that recusants remain covered by its obligations, albeit as guests or resident aliens. Note, however, that this elaborate argument is itself necessitated precisely by the paradigm status of civic membership. It's itself reinforced by Duff's perhaps not so thin legal moralism, as in the case of his rationalization of the existence of mala prohibita. The approach is to incorporate what he sees as outlying cases by reference to what he sees as the paradigm, and not to consider whether their scope or importance in fact undermines that paradigm or raises questions about the principles on which it is based. In a pluralist society, it is not really appropriate to regard internalization of shared civic values as a core and necessary aspiration of In a pluralist society, is it really appropriate to regard internalization of shared civic values as a core and necessary aspiration of a decent polity? Vigorous debate and dissent are surely central to any truly open pluralist society, and this, I would argue, militates against the highly moralized version of political community on which Duff wants his account of criminalization to rest. In conclusion, Duff's book is meticulously argued to a degree that makes it hard for the reader to be confident that she has grasped all the relevant distinctions and all the nuanced caveats and qualifications. In an effort to concentrate on the central elements of his account, I am acutely conscious of having engaged with only a fraction of his comprehensive argument, which spans legal substance and procedural doctrinal arrangements in their institutional settings, and issues of legal, political, and moral philosophy. For the reasons set out in this article, I cannot follow Duff along the road of legal moralism, but he stands as its most sophisticated and subtle defender. The realm of criminal law consolidates his already towering position in the field. Okay, I must say, this paper was a mouthful. If there's anyone out there has any questions about it, let me know. I mean, this was really packed a punch in not a lot of space here. This was only, 10 pages, but it was dense. So, 11 pages, excuse me. It was rather dense, and there were a lot of big words. This is philosophy, but yeah. So, what's said? This was, like I said, well written, well argued, but sometimes it sort of, it's hard for me to grasp when reading it in real time, because it was very sophisticated. Some of these sentences were rather sophisticated, but still. It was, for the subject matter, I'd say it was rather well done too. So basically, this focused on why you shouldn't be a legal moralist, according to Duff, or a Duff-style legal moralist, because it has problems with how society is. It's too aspirational. Then in the second one, it says, well, what was this one? It's not a rational reconstruction, it's an aspirational reconstruction, but that fails on the actual practices. And then what are you talking about? Then what does it count here as what are you regulating? So, okay. Yeah, how do we actually, who gets to decide what counts as a law, and then who actually is a citizen at that point too? Okay. So this is just dense, and so hard to come up with a lot of things, but it looks like the density of the original book yielded a dense argument, and then this was a dense reading of it. And I just feel dense in the head at this point. So that's about it, but it was a very impressive article, really. Lots of stuff. Okay. Interesting philosophy of criminal law and how we actually understand what counts as being criminal. So I think that's it for now. I've got a few people watching. Please let me know if you have any questions or suggestions for the next episode. I always like suggestions, anything to read you think is interesting, or comments on what I should do. But yeah, have a good day, everybody. Stay safe out there, and I will be back with you soon. Thank you, Sinful. Appreciate it. Thank you. Thank you guys for stopping by and your questions. I appreciate all of those. All right, have a good day. I'm going to cut the stream now, though.